Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, do I take the Constitution as before?
Good afternoon, please be seated. Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is case number 01-21-00571 CR, Jason Boatwright versus the state of Texas. Will counsel please make your announcements?
Counsel for Appellant Creston Linton here for Jason Boatwright.
Okay.
Counsel for the state, Zach Anderson.
Thank you. Each side will have 15 minutes for argument. Does appellant wish to reserve any time for rebuttal?
No, right.
So 0 minutes for rebuttal?
Yes.
Okay. Okay. Very good. We're ready to proceed and hear from counsel for appellant.
May it please the court, counsel.
Yeah, judges, good afternoon to you. I'm here for Jason Boatwright on this appeal. Mr. Boatwright was arrested for possession of a controlled substance, methamphetamines, about 30 grams, on March 7th of 2020. After a motion to suppress hearing before the district court, that was a motion to suppress was denied. He took a plea of 3 years deferred adjudication, and an appeal was filed.
So what's our standard review on the motion to suppress?
Abuse of discretion, Your Honor.
Abuse of discretion.
Of the trial court.
And the trial judge heard testimony?
Yes, Your Honor.
And the trial judge evaluated the credibility of the testimony?
Yes, Your Honor.
So how can we say that the trial court abused its discretion in making the factual determination about probable cause or suspicion?
Your Honor, I believe there was an abuse of discretion because of the fact that the officer is claiming that he had probable cause. There's a claim of probable cause to go into the car, and then eventually sees the methamphetamine that's in some type of a travel bag.
And so the probable cause that the officer stated was?
That he saw marijuana in a third pill bottle, Your Honor.
And anything in addition to seeing the marijuana?
He was claiming that he also believed that Mr. Boatwright was intoxicated, which led to the accident at the Planet Ford service bay where this vehicle was being serviced.
So let's say that there wasn't marijuana, and would the behavior that the officer noticed, would that have been sufficient to give probable cause?
No, Your Honor, because Mr. Boatwright, with this unusually designed car, I guess his foot slipped on brakes and a fellow employee was pinned against a wall and had to be taken to the hospital. And so when an officer says that Mr. Boatwright is nervous, that he cannot name the substances that are in the 2 pill bottles that he's taking, that he can't spell it, that is not enough that I would suggest for any type of probable cause to be able to get into that car.
What's your best case for that the behavior is not sufficient?
I believe but the behavior that was exhibited by Mr. Boatwright is actually consistent with someone that was terrified that he had killed a coworker or had severely injured a coworker.
Could it also be consistent? I mean, yes, that is consistent with that, but could it also be consistent with someone who is intoxicated?
It could be, yes, Your Honor.
So wouldn't that be probable cause or reasonable suspicion?
That might be probable cause for reasonable suspicion to take Mr. Boatwright aside and give him a field sobriety test. Do walk a straight line, lift your right leg, do the nystagmus gaze test, do a finger count, do any of the things that an officer would do if he pulled someone over on the side of I-10 for a field sobriety test at 2 o'clock on a Saturday night. That these are the things that should have been done by Officer Thompson, is to determine whether or not Mr. Boatwright was intoxicated, not to yank him out of a car and then say that that's reasonable suspicion and probable cause, or probable cause for him to go inside the car
Right,
and
so-
search this bag that's on the passenger side.
So that's your answer if there wasn't marijuana. So now we have behavior with the plus factor of something that looks like marijuana. And why is that not probable cause or reasonable suspicion?
Because it is just as possible that it's a legal substance as it is an illegal substance.
Okay, well, now we have to trust the police officer's judgment and the trial court's determination of the police officer's judgment. So we have this behavior, which is suspicious of something, right?
Correct.
As you conceded, with something which has, let's say, a 50-50 shot of being marijuana. Why isn't that enough to do a search?
Because the fact his first thing he should have done is determine whether or not he was intoxicated. It's not a search to go in the car. This is not a car that's on the side of the road that he has the ability to drive off or the ability to go in there and get a gun. These factors do not determine whether or not he should be able to go in there and search it all. It's to determine whether or not he's intoxicated. Because if the officer believes he's not intoxicated, then there wouldn't be any need for any further search.
So if the standard is reasonable suspicion, right? And now I'll set aside behavior and let's just talk about the marijuana. And he sees something which has a 50-50 chance of being marijuana. Is that not a reasonable suspicion that it actually is marijuana and it would justify a search?
Well, Your Honor, I would disagree that it's a 50-50 shot of being marijuana. We don't know what it is. Because of the fact that with the new law being passed, hemp looks just like marijuana. Or certainly biologically, it is the same thing. We don't know whether or not it's under the 0.03 THC versus over the 0.03 THC.
Right.
So to say 50-50, I don't know what the percentage would be. I just know that since they look just alike.
But all it has to be is a reasonable suspicion. So it could be not 50-50, it could be only like a 10% possibility that it's actually marijuana. Where, I mean, if, I think I'm being generous by saying 50-50.
Correct.
I sort of fail to see why that isn't a reasonable suspicion or a probable cause for further investigation.
Because if you're going to be stopping somebody, if you're going to be investigating somebody for driving while intoxicated or causing this accident by intoxication, the first thing would be whether or not he was intoxicated, not going into the car, or he could have gone into the car and grabbed the marijuana. There was no need to go searching throughout the rest of the car.
But didn't he actually go into the car and provide two of the bottles, pill bottles, to the officer voluntarily?
Yes, Your Honor.
And it was only when the officer saw that there was a third one that he seemed to be concealing that he pulled him out of the car.
Yes, Your Honor.
And so didn't he participate in the process by offering the other bottles to the officer to examine?
Well, he certainly, I mean, it was a consensual encounter between Mr. Boatwright and Officer Thompson.
And you're saying that it ceased to be consensual when he pulled him out of the car?
Correct.
That was the point at which it became non-consensual?
Correct. It became non-consensual when Mr. Boatwright said he didn't want to, well, I guess when he mentioned the warrant, and then the officer changed his point of view at that time as well. So that's when the consensual nature of the encounter stopped.
I think the
And-
officer, I'm sorry, I didn't mean to interrupt you. I
Yes,
think the
sure.
officer testified that the behavior and the movements of your client made him nervous, concerned about maybe for his safety. If that was a reasonable view of being nervous about the movements and the behavior of your client that perhaps could endanger him or place his safety at peril, would that have given him some reasonable suspicion to pull him out of the car, in your view?
It could have been reasonable suspicion to pull him out of the car if he thought that maybe he was going to be reaching for a gun somewhere in the car. But once he's yanked him out of the car, then there's no more fear that he's going to be able to go back into the car and go into a glove box, into a bag, underneath the seat, anything like that, to pull out a gun to harm the officer. So there's no need to go any farther. One thing that was brought up by by the state's counsel was that there was another reason for criminal activity, which was the transporting of hemp. And I would suggest that this statute has more to do with the manufacturers, people that are farming hemp, transporting it to various places to sell, not someone who has a particular piece of hemp in their car. So that particular statute would not apply, that this would be any type of criminal sanctions having to do with having a piece of hemp in the car. That statute also has a provision that talks about civil penalties as well. And so I certainly do not think that this is a criminal statute that would give the officer extra reason to go inside the car or to go inside the vehicle.
If the officer had, I think you just said, the officer had reasonable suspicion to pull him out of the car if he was concerned about his safety, would the reasonable suspicion associated with that detention of pulling him out of the car then, would that then also give him justification then to conduct some type of limited search of the car and make sure there wasn't a weapon in there?
Well, no, Your Honor. The idea, my argument would be that once he has taken Mr. Boatwright out of the car and moved him away from the car, the officer's safety, at least as far as something that's in the car, is no longer going to be an issue. He could certainly pat down Mr. Boatwright to determine whether or not there's any weapons on him in a pocket, in his pants, and a shirt. But inside the car, that fear is no longer there because Mr. Boatwright's not in there.
Do you have a case that you're relying on for that interpretation of that legal test?
I do not, Your Honor.
And Mr. Boatwright was not actually detained when he was pulled out of the car, was he? He was not in handcuffs or any kind of constraint?
That's correct. He was not.
And so there's nothing that would have prevented him from going back into the car at that time?
Well, I guess there's nothing except an officer had just yanked him out of the car, so I do not think he was going to be able to go back in, short of starting a fight. And just to go over the McKnight case out of Colorado, that if that particular court has issued a decision that if a dog cannot distinguish between an illegal and a legal substance, whether it be marijuana or cocaine or methamphetamine, that Mr. Thompson, again, the officer Thompson, would not be able to distinguish between something that is legal, hemp, and something that is illegal, which is marijuana.
Did we have a dog sniff in this case?
Excuse me, Your Honor?
Did we have a dog sniff in this case?
We do not, Your Honor. It is just an analogy that is provided that since there's two different substances, one could be legal and one that's illegal. In the particular case in Colorado, that would be between marijuana, which is legal, and a legal substance. The dog could also put a signal on as well.
So what if the officer had observed, say, a vial of white powder? Are you saying that because it could be talc or salt, that would not be probable cause to do a search for more illegal drugs?
The officer would have to be able to testify at court that due to his experience and his knowledge, that he could distinguish between, say, cocaine and sugar, or cocaine and talc powder, or methamphetamine and talc powder.
So he has to say he was able to distinguish it? So what I'm getting at is, the officer is presented with a question, he needs to seek the answer to the question. He can't tell just by looking that it's hemp or marijuana. He can't tell just by looking that it's meth and not baby powder. So that reasonable suspicion is what gives him the authority to conduct a further investigation, do a further search. So, I mean, I think it's unrealistic to adopt a standard that the police officer has to know for certain what he is looking at when the test is actually reasonable suspicion.
Yes, Your Honor, except that I think that if you had a picture of methamphetamine, I mean, if you had the substance of methamphetamine or cocaine versus baby powder, Johnson's baby powder, that someone could take a look at these substances and they could distinguish them just by looking at them. Certainly, he's not going to know exactly what it is, but there's enough of a difference between illegal.
All he sees is a vial, right? And he can't, he's not seeing a pile of powder. He hasn't even touched it yet because he. So you're saying he would have to know that it is in fact cocaine or methamphetamine before he actually can do it?
I think he would have to be able to testify before the trial court that in his belief he really thought that looked like methamphetamine or it looked like cocaine, that it looked like an illegal substance instead of something that is just as legal like Johnson's baby powder.
What if it was a gun, sort of a prop gun? Would he have to be able to distinguish the difference? Something he sees several feet away. Would he have to distinguish between a prop gun and a real gun, or would he have probable cause to search further?
Well, I guess if he saw what he thought was a gun, then he would have probable cause to be able to go in there, unless it had something on it, like I think they have some of these little orange tops that you
Right.
can
So
put on
here he saw what he thought was marijuana. Was that a reasonable surmise for him to make?
Could be, but since they're both the illegal substance and illegal substance look just alike, I would say no.
I have no further questions.
Any more questions? Well, counsel, you're up. Thank you very much for your arguments. We
Thank you, Your Honor.
appreciate them. We're now ready to hear from counsel for Applee.
Good afternoon. My name is Zachary Gibson, and I'll be representing the state of Texas, opposing counsel, and Mr. Chief Justice, may it please the court. In this case, the appellant had been involved in a traffic accident at a car dealership that sent someone to the hospital. The appellant was acting in a way at the scene with the officer that made him suspicious. The appellant's speech was very rapid. He was unable to understand him at times. The appellant indicated that there had been medication in the car.
Let me ask you a quick question while you're talking about his behavior. Actually, the same question I asked counsel for appellant. Did his behavior and his movements that were erratic according to the testimony of the police officer? He said those movements and his behavior made him nervous, the police officer nervous, and concerned for his safety. Based on his evaluation of the circumstances and based upon his feeling of potentially being unsafe, did that give him reasonable suspicion to detain him in terms of pulling him out of the car?
Yes, Mr. Chief Justice, it certainly would. So there are two things challenged in the appellant's brief and in the case. One is the decision to pull him out of the car to put him into custody, or to put him into detention, I should say.
Right.
That would be reasonable suspicion for that, because whenever Mr. Boatwright got back into the car, it wasn't just that he got back into the car and wouldn't come out. He was turning his body so as to block the view of the officer. The officer was concerned about two things. Number one, destruction of evidence, but also potentially accessing a weapon. So it would provide reasonable suspicion to elevate it to a detention. And the state does certainly agree that it was a detention at that point. It was probably not full custody, but it was a detention.
Well, grabbing him to pull him out of the car would put him under
Correct.
detention, right?
Correct, it would. And there would be reasonable suspicion for the detention. At that point, the officer had two things given the facts of the case. Number one, he would have reasonable suspicion to do a limited search of the car for weapons, which would get him into the travel bag in the front passenger seat. I think that would be roughly analogous to the leather pouch in Michigan versus Long. So that is one justification for getting into the leather pouch. And of course, once he sees the drugs in there.
So that'd be he have justification under that analysis to do a limited search for weapons?
Correct.
Because
And it would be weapons for things that could injure the officer. A travel bag, I mean, this is common knowledge, a travel bag could be large enough for a knife, for a gun. Part of the justification for Michigan versus Long, as was pointed out, is that since he's not in full custody, it is possible in situations like this that an officer could do further investigation and decide, no, I'm not going to arrest him, meaning that he gets to go then back into the car where he would have access to all of this. So that's part of the reasons why he would be especially concerned about weapons in the car itself.
terms of the search, so if there was a reasonable suspicion based on behavior and concern for safety, if that justified a limited search of the car, when I asked appellant's counsel the same question, he suggested that there was a legal basis to maintain that the search was limited basically to what was ever in plain view, if I understood the argument or the answer correctly, and not to go into the enclosed area, the area in between the seats. Is there any case law that limits the search is limited, but how limited?
No, I think the most obvious case would be Long itself. I understand that's a foundational case here. There are also cases out of this court interpreting Long that are cited in our brief, but in Long it was a leather pouch. Now it's true it's not the full invasive search under Long that would be for probable cause. Now probable cause is also present here, but if you had just a Long search, you might have difficulty justifying getting into like very obscure parts of the trunk. But here, since you're in the passenger compartment, you're in an area that's very easily accessible to getting back into the car, I would think this would fall fully within the scope of Michigan versus Long and the cases that are interpreting that. As to the issue of probable cause, because the state certainly doesn't want to concede that there was not probable cause, there is probable cause of two things here. Number one, for DWI. So putting aside the legalization of hemp, I don't think anybody questions that the marijuana plant, I understand marijuana is a legal categorization, it's illegal, but the marijuana plant, cannabis sativa, I think it has the capability of being an intoxicating substance. So in this case, the appellant has taken medication, there's been a traffic accident, he's pinned a guy to the wall, his speech is very erratic. Whenever he sees the intoxicating substance, and there are several cases we cite, one of them is actually a Massachusetts case in our brief, and Massachusetts is a case that has fully decriminalized small amounts of marijuana. So even if you have a case where marijuana might be legal, it's like beer in a car. The beer is legal in many circumstances, but it's the fact that it's evidence of a DWI. And so you have that, plus you also have the pills, which can also cause a change in your mental behavior.
Can I ask you about the
Sure.
2 pill bottles that were pulled out before they did the search for the third one? What were those pills?
I don't recall from the testimony.
Well, I know some medications can result in odd behavior and side
Sure.
effects and things like that.
Sure, and I remember from the testimony, I did not get the impression that the officer was terribly concerned about these first 2. What happens is when he gets back in the car and he sees the third pill bottle, he comes out looking very concerned. Reading between the lines, I think what happened is he got back in the car, looked in the third pill bottle, and probably realized, there's actually a bud of marijuana in here, as well as maybe something else. But it was the change in behavior between he looked in the third pill bottle, he came out without it, and that's whenever the very nervous behavior began. He was probably nervous the whole time, but it was especially after the third pill bottle came up. I don't recall what the medications were for the first 2 off the top of my head, but I don't recall the officer being terribly concerned about those 2. It was mainly the change in behavior about the third pill bottle.
Let me just ask if those 2 pill bottles were ordinary medications but have side effects that can lead to wooziness or some change in behavior, would that have changed the circumstance of this case?
It very well might have. It might have given probable cause to search for evidence of contraband fully irrelevant from the marijuana. I mean, one of the problems with this case is that we get lost in the legalization of hemp. That is a factual issue kind of floating below the surface, but there's really not a need to get to it because a lot of things can be perfectly lawful, but you just can't drive. Hydrocodone is one, for example. I don't recall in this case that the officer was concerned about the first 2 medications.
So is it the totality of the circumstances that you're primarily pointing to?
Well, yes, and it is also the side of marijuana. So it's very clear from case law that courts have upheld the ability of officers visually to distinguish the marijuana plant from something else, oregano. Everyone knows, and officers know, that has an intoxicating effect. It is true that if it were hemp, it might not be contraband per se, but if it has an intoxicating effect, it could still be evidence of a DWI. So it isn't just probable cause that he was possessing contraband. We believe that is here, based on the facts. But it could be evidence of DWI, in the same way that seeing a half-open beer can would allow you to then search the car for other beer cans, because it could be evidence of a DWI. So there's that probable cause. The second probable cause, and again, we don't necessarily have to get there because we've got the DWI, but the second probable cause would be for the marijuana. So it is true that in Texas there has been a very small decriminalization of the possession of the marijuana plant, but it is extremely limited. It's not something the average person would necessarily want to possess. And all of the federal courts where they have, hemp is legal in this very small subset, have all said that seeing the marijuana plant, unless there's some other facts, it's going to be at least probable cause to think you've got contraband. Now, it might turn out to be hemp. That was true in the Brignon case, I think, if I'm saying that right, the federal case. But as for probable cause, an officer is usually going to be able to get there. Now, that's the hypothetical of just viewing marijuana, but of course, when you see something that you know is the marijuana plant, and you have all the guilty behavior associated with it, trying to hide it, trying to this, that's further evidence to think that the defendant at least believes this is contraband and not legal hemp.
If we were to weigh the facts, as we're reviewing the facts here, and if we were to take a different view of the facts than the trial court here on the motion to suppress, in terms of the behavior and the overall facts, would that give us a basis to reverse the trial court here?
I don't believe that it would. I mean, first of all, I'm going to answer your question. If there's something you don't view the facts on the same way, it would have to be legally dispositive. And here, because the state has so many bases, it would probably not. But second of all, back to the standard of review, it is true that the legal conclusions are reviewed de novo, but the credibility, inferences from facts, that's all viewed most favorable to the trial court's ruling. That's especially the case when we don't have written findings. Back to the McKnight case out of Colorado, it's a drug sniff, it's a dog sniff case. In our brief, we go into why the state thinks it's first of all decided under the Colorado Constitution, so it's insulated from Supreme Court review. We think the dog sniff analysis is probably wrong. But even putting that aside, Colorado is different in the fact that they have completely decriminalized marijuana, now granted for small amounts, it's just completely legal. So it is true that possessing hemp or possessing the marijuana plant in small amounts can be legal in all circumstances, no matter how much THC is involved. Texas is different, and we're much more analogous to the federal standard, which we borrowed from, and also from the states. I believe it's I forget the page number of our brief, but we cite a number of states where they had medical marijuana regimes, and the courts all look to the fact that it's a very narrow legalization, very narrow set of facts. So unless you have something else, it's generally going to provide a probable cause. And we believe that case law is analogous. Unless there are further questions?
Further questions?
The state yields its time. Thank you very much.
Thank you very much. Since there's no time reserved for rebuttal, case is submitted and we are adjourned.
All rise.
But I didn't remember your name associated with it. So it's I think I have met you before, but it's been a very long time. Which trial court were you in? Oh, I was in several. I was in 8, 6, 12. Yeah. And then I was in the 177 for a long time, and then I got moved. So, but yeah, I was down. That's since 2018. So, but anyway, no, it's good to see you. Enjoy your keychain.
I certainly will, thank you.
Somebody gave me that. That's one thing I don't need. I'm all good with that.